Good morning, judges. May it please the court, my name is Jasmine McMackins Hatcher. I will reserve 3 minutes for a rebuttal.
3 minutes?
3 minutes
All
is
right.
fine.
You may proceed.
Yes, sir. I am from the Carroll County Bar. I represent Miss Brittany Ferris in this matter. I'll apologize in advance for my voice. I guess 'tis the season for scratchy voices. Thank you for having us this morning on behalf of Miss Ferris. Won't waste the court's time with rehashing much of the procedural history or even the facts. The court will have the luxury in this case to review a very thorough record from the trial proceedings below. Hours of trial testimony from what I believe to be credible witnesses and many exhibits. I would like to start with just a brief recitation of the facts. This case arose after the Department of Children's Services removed a minor child from the parents, Brittany Ferris, again my client, and her husband Zachary Ferris on August the 1st of 2019. And then subsequently, the Department of Children's Services filed a petition to terminate the parents' parental rights. The issue was raised in the briefing, the state's briefing, and several times in the trial court's rulings and findings of fact that the parents failed to show a sense of urgency following the removal of their child to try to restore custody to them. Having had a front seat to their response, I would submit to the court that that's not true. The parents did take a very adversarial stance against the Department of Children's Services following the removal of their children. They participated in a preliminary hearing in the Juvenile Court of Carroll County in hopes of getting their child restored to them. They participated in a adjudication hearing in the Juvenile Court of Carroll County, again in hopes of having their child restored to them. They appealed the decision of the Juvenile Court to the Carroll County Circuit Court, participated in a lengthy hearing there, again in hopes of having the child returned to them. In fact, they appealed that decision to this court in efforts to having the circuit findings overturned, and then the father elected to have a jury trial, again in the Carroll County Circuit Court, for criminal charges that he incurred as a result of sort of the same facts that led to the removal of the children. At the conclusion of those legal proceedings, and I submit to the court that the parents elected to exhaust all legal remedies available to them, and that obviously took some time to get through those legal proceedings. At the conclusion of those proceedings, Ms. Ferris was confronted with the harsh reality that she had lost. She had lost her child, and she had now lost her husband. I submit to the court that she probably had a lot of options available to her, but that she made the only one that was correct, and that was to begin working with the Department of Children's Services towards what she hoped was reunification with her child. The record is full of evidence of progress that the mother made towards sobriety and stability following her husband's incarceration. The record is void of any evidence of relapse or backsliding following her husband's incarceration, and that incarceration would have been in October of 2021. Despite the mother's forward progress, the Department of Children's Services still moved forward with their request to terminate the mother's parental rights. Typically, in appeals, I spend a lot of time focusing on what the trial court got wrong and trying to convince your honors to reverse those decisions. I want to take the rest of my time to focus on what the trial court got right, some findings that they got right.
Let me ask you
Yes.
a question. You primarily talked about best interest thus far.
Correct.
Is there an issue with the grounds?
In this case, there's not, Your Honor. The parents made a educated, calculated decision not to contest the grounds alleged against them. Specifically, the department had alleged, I believe it was 4 grounds originally, non-suited on 3 of those, and only proceeded on the ground of severe child abuse, and we did not contest that at trial, nor did we raise that issue on appeal before the court.
The circuit court order as far as the severe child abuse, was that appealed?
It was appealed by Mr. Ferris, and that appeal was subsequently dismissed. I believe it was N. Ray Reagan B. was the title originally, and that was dismissed. And that was dismissed prior to The second trial, if the court reviews the record, there was a trial that began in March of 22. We started over in 23, and the appeal was dismissed prior to the beginning of the second trial, and we submit to the court and concede that the findings of severe child abuse against both of the parents would have been res judicata and not an issue on appeal.
I just tried to make sure I had.
Yes, you are
everything
correct
straight.
that our focus is the best interest, and the court, the trial court, did a good job with the facts that it had in front of it and making findings of fact regarding best interest. There are three that I want to highlight for the court today. First, the court found that after the department filed a petition to terminate the parental rights of the parents, it ceased its efforts to reunify the child with the parents, specifically the mother. Second, it found that the mother is clean from drugs and has a home suitable for nation's needs. And third, it found that Brittany Ferris's home seems healthy and safe for nation. I submit to this court that those three findings of fact taken together or even separately could be enough under the best interest analysis for the court to have denied the petition. That brings me to the first issue that I did raise on appeal, was whether the court applied the wrong, if you will, best interest factors. At the time of the department's initial filing in July of 2020, the best interest factors enumerated in the code section, there were 9 of them. The department filed an amended petition in February of 2022 alleging and citing and enumerating those same 9 factors, even though a new set of factors had come out in between the 2 filings. The department could have amended its pleadings and its supplement and presented the new factors in the petition, but they did not. They literally enumerated factors 1 through 9, putting the mother on notice that those are the factors that she is in fact defending. That is the department's way of telling the court these are the 9 factors that we believe apply to the facts of this case. I would submit to the court that the 3, specifically the 3 findings of fact that I just highlighted for the court are enough under the old analysis to have required the court to deny the termination of parental rights. When you've got a fact pattern where the department admits that they stopped the reunification process because of the filing, not the granting, not the going forward, the filing of a petition to terminate a parent's rights, they stopped the reunification process. And
Aren't they allowed to do that?
Your Honor, I submit to the court they're not. The department has an obligation to make reasonable efforts towards reunification until a court relieves them of that right. Now, following the finding of severe child abuse, I think the department could have asked the court to be relieved of reasonable efforts, but that was never done. There's nowhere in the record that you will find any order relieving the department of their obligation to make reasonable efforts.
Did you file anything to ask the court to change that?
No, the department never made a request to be relieved.
No, did you?
No, I believed at all times during the representation of the parent that the department maintained an obligation to make reasonable efforts towards reunification.
You didn't file anything with the court, though, asking the court to order the department to make these efforts?
No, and to be honest with the court, it appeared to me that at the time of the representation that the department was continuing to make those efforts. They were arranging visitation. The mother was required to drug screen for the department. The mother was required to continue working the steps. I didn't really learn of the department's opinion about reunification until we started requesting the increase of visitation and would consistently be denied. And then through the trial testimony at the termination proceeding, the department's witnesses actually testified that once the goal of return to parent was removed from their later developed permanency plans, they did not believe that increasing visitation or rewarding the mother's progress would have been in the best interest of the child. It was really their admissions at trial.
Did your client not receive a revised permanency plan?
My client participated in the development of all of the permanency plans and noted her objection to the sole goal of adoption on all of the plans. There actually wasn't a ratification hearing for the last, I believe, almost year of the case. I can't say sitting here from the podium when the date of the last plan was ratified. I do know there weren't any plans ratified roughly for the last year because...
Is that when the change took place?
Your Honor, I won't try to mislead the court on when the goal of return to parent was removed. I know it ultimately was removed. That was the department. The department believed that was in the best interest of the child to at some point remove that goal. But I think the department's testimony at trial, and you will see in the record, was that they had originally told, and I believe the state's brief, they actually quoted some of the proof, that although DCS initially told the parents that visitation could be increased if they tested negative on drugs, DCS did not increase the mother's visitation following her clean drug screens because return to parent was no longer a goal on their permanency plans. And again, this is language from the state's brief in this matter.
I understand what you're saying, but the way I understand it, and
Yes,
I
sir.
could be understanding it incorrectly, obviously, is when those permanency plans are approved, those goals are set out. And that's the whole, or at least a portion of the idea, is that everybody's on the same page about what the goals are and what the requirements are. So your client would have been aware that this reunification was no longer the goal.
My client was made aware that the department's position was that reunification was no longer their goal. It was never her goal, and she stated her objection to the department's goals on every opportunity that she...
Yeah, but this isn't like we're hiding the ball on you.
No, they were not. I'm not suggesting to the court they were hiding the ball from the mother. What I am telling the court is, as she began to make progress, the department at no time rewarded her, as we typically see in these types of cases. As you start passing drug screens, as you establish a home and a license and stability, you see those visitations increased. That was never done in this case, and it appears that the department had made the unilateral decision, sort of unbeknownst to the mother, that they were not willing to reward her progress at this time. I'll reserve my other statements for my rebuttal.
Thank you. I will note for the record, we have, which appears to be, this isn't coming out of your time, so.
That's okay.
A waiver of oral argument filed today on behalf of the father, where he's waiving oral argument and relying upon his brief. It's, I don't know if the parties were aware of that, but.
Thank you. We were not aware. I appreciate that.
Yeah, you may proceed.
Good morning, Your Honors. My name is Carrie Paris, and I'm here on behalf of the Department of Children's Services. The juvenile court properly terminated mother and father's parental rights after finding clear and convincing evidence supported 2 grounds for termination.
I think you're going to need to pull that down just a little bit more.
Sorry.
There you go. Thank you.
And that termination was in the child's best interest.
Thank you.
As my opposing counsel said, there is a res judicata severe abuse finding against both mother and father. However, there was a second ground against father, and that was that he was sentenced to more than 10 years in confinement when the child was under 8 years of age. Now, if this court, or neither parent challenges these grounds for termination on appeal, if this court doesn't have any questions on them, I have briefed them, and I will focus my argument predominantly on the best interest factors as they apply to mother. First, to address the reasonable efforts issue, the department would argue that they did continue reasonable efforts up till trial. As mother began testing negative on drug screens in July of 2020, and DCS facilitated those drug screens. They also did a home visit right before trial and facilitated visitation. So the department would argue that they did continue to make efforts to track mother's progress and facilitate contact with the child. Focusing on the best interest factors, and finding that termination was in the child's best interest, the trial court applied the new amended factors. This court does not need to determine which set of factors should have applied, as the new amended factors incorporate the previous factors into their analysis, and neither set of factors is an exhaustive list. Therefore, the trial court's application of the new factors can be upheld and at most constitutes harmless error.
Aren't there cases that indicate where there's an amended petition filed, and that amended petition is after the new factors, that you apply the new factors?
That is correct, Your Honor.
All right. And that's what happened here, isn't it?
That is what happened here, although the department will admit the supplemental petition that was filed did continue to allege the old factors.
Okay.
But it was filed in February 2022, which is after the factors were revised. Regarding factors C and M, the parents had not demonstrated stability in meeting the child's needs, nor a sense of urgency in addressing the conduct that made an award of custody unsafe. By trial, the child had been in DCS custody for 3.5 years. The parents continued to use methamphetamine throughout this case, up until father became imprisoned in October 2021. The parents showed no sense of urgency in addressing their substance addiction, refusing even court-ordered drug screens, and failing to acknowledge their addiction on assessments. Though mother was sober at trial, she waited over 2 years to begin making progress and admitted she had only been sober for 1.5 years out of the last 12 years. Mother also acknowledged that she had not been forthcoming about her methamphetamine addiction in her Suboxone treatment clinic, which treated her opioid addiction. Mother's doctor from the Suboxone clinic recommended inpatient recovery, which mother had not completed by trial. The parents have shown no ability to care for the child or provide a structured environment given his extensive needs. This child has been diagnosed with autism spectrum disorder, post-traumatic stress disorder, ADHD, anxiety disorder, sensory integration disorder, speech and language delay, and fine motor and gross motor delay. The child receives 4 to 5 weekly therapy appointments and requires a stable, structured environment to remain regulated. The parents have shown no ability to provide that. Therefore, the trial court properly found these factors favored termination. Regarding factors H and I, the child has a healthy parental attachment with his foster parents and emotionally significant relationships with his 3 foster siblings. The child has expressed his desire to stay with the foster family, and foster parents desire to adopt the child. The foster parents have 3 other children which the child is bonded to. The child's therapist said the foster parents are the child's whole world and that losing that relationship would be very traumatic for him. The child has spent half of his life in the same foster home, and this is the only home he remembers. Therefore, the trial court properly found these factors favored termination. Regarding factors D and E and their corresponding old factors, number 3 and 4, the child did not have a secure and healthy parental relationship with the parents, and visitation with the child cultivated a friendship with mother rather than a parental relationship. The child described mother as his friend and did not ask about the parents outside of visitation. The child saw his foster parents as his parents. The child called mother and father, by their first names and did not like to be redirected to call them mom and dad. The child had no relationship with father as he refused to speak with father on the phone even when he called in during mother's visits. Additionally, the child exhibited increased behavioral issues following visitation, which therapist Vivio contributed to a trauma response. These factors favor termination. Regarding factors A and B's corresponding old factor number 5, termination would have a positive effect on the child's critical need for stability, and a change of caretakers would be detrimental to the child. The child remained in the same foster home since August 2019. When the child first came into custody at 3.5 years old, he did not speak. And when he started attending preschool, he needed one-on-one assistance in order to stay in the classroom. The child had significant needs due to his various diagnoses and attended multiple sessions of therapy and appointments per week. The foster parents, as a level 3 therapeutic foster home, prioritized this child and ensured that he got the medical care he needed and attended appointments. At the time of trial, the child's behavior had significantly improved, and he was able to be in school with less support. These factors favor termination. Regarding factors K, J, and T, and their corresponding old factors 1, 2, 7, and 8, mother and father did not take advantage of available programs or make a lasting adjustment of circumstances, and their mental fitness would be detrimental to the child. Mother did not begin cooperating with services until October 2021, after father became incarcerated. Prior to father's incarceration, both parents refused drug tests, were untruthful on assessments, and continued to use drugs. Even though mother was in a Suboxone treatment clinic, she was not forthcoming in this program regarding her methamphetamine use, and she had not completed inpatient recovery as suggested by her doctor. Further, mother had only been sober for 1.5 years out of the last 12 years. The trial court found that mother was in a fragile condition. These factors favor termination. Regarding factors G, O, and P, the parent's household exacerbates the child's trauma, and the parents have not demonstrated an understanding of the child's needs, nor have they ever maintained a safe home for the child. Mother's home exacerbates the child's trauma as exhibited by his increased behaviors following visitation. Therapist Vivio believed the child experienced a major trauma before he developed language skills. Mother had not provided a healthy and safe home for the child for reasons including failing to address her substance abuse issues and living with grandmother, who was a substantiated perpetrator of child abuse at the time of trial. Nor had mother provided a safe home for her other children, as none of her 6 children resided with her by trial. The child requires a heightened level of care due to his diagnosis and resides in a level 3 therapeutic foster home that receives specialized training each year. Mother has not demonstrated an understanding of the child's significant needs, nor his need for stability and routine. These factors favor termination. It is the parent's own inaction and resistance to services for the first few years of this custodial episode that resulted in this child developing a strong parental attachment and relationship with the foster family. Resolving any best interest conflict in favor of the child and viewing the best interest factors from the child's perspective, the trial court properly determined the factors overwhelmingly favor termination.
You mentioned that mother did not begin making what you termed to be efforts, I think, until after the father went to jail.
Yes.
What's the status of the mother and father relationship, or what did the trial court find?
At the time of trial, mother testified that she still had a relationship with father and planned on reuniting with him when he got out of jail. I believe she had visited father right before trial in prison.
Good. But the trial court made a finding that mother didn't begin making these efforts until father went to jail. Is that
Yes.
accurate?
Yes.
Okay.
Sorry. Any other questions? Thank you, Your Honors.
I'd like for you to follow up on that. That's a concern here, is that apparently a prioritization of relationships here, and it seems that mother prioritizes relationship with father rather than the child, or at least that's what the trial court seemed to find. And
Yes, Your Honor.
so where are we?
Yes, Your Honor, that was certainly, it was not necessarily an emphasis of the trial court in its ruling and its finding as a fact. It wasn't necessarily a reoccurring theme. It was addressed that the mother she was married. First of all, they are married and they're still married. I believe that the testimony, when you review the record, the mother's testimony was that she remains a support to him while he is serving a very lengthy prison sentence, and at this time that relationship is healthy for her. In the event that the relationship becomes unhealthy again, as it admittedly was during the removal of her children and further beyond that, that is a relationship that would have to end. And I believe that's what the mother's testimony at trial was, that at this time it was healthy, it was a support, if you will, but if it needed to end, that it certainly would. I submit the court that the trial court did not focus on that in its ruling, although mentioning it. I believe the state and the trial court made an error that this court is advised against, and which is essentially going through those factors and doing that rote examination and then sort of tallying which factor goes for and against. This court is advised that, one, that's not necessary, and it's probably not even proper. This court has stated that one or more factors can turn the whole analysis on its head. And I would submit to the court that these strong findings in favor of the mother, specifically that the mother is clean from drugs and has a suitable home to meet the child's needs, and that the mother's home is healthy and safe for nation. If you take those two findings of fact.
Aren't we missing the point here, though? The point being that once grounds are found, we're looking at the best interest of the child, not the best interest of the parent.
I do agree. I do agree, and the law is clear on that once grounds are found, the emphasis, the emphasis shifts and the focus is on the child. But having a child that will be able to see one day that the time that his biological mother's parental rights was terminated, she was clean from drugs and she had a safe home.
The safe home, is that the home with her mother?
That is the home with her mother, yes, Your Honor.
Weren't there indications of problems with the mother's home?
There were, that had been previously alleged, but that proof was not focused on in the trial, and there were no findings of that I recall in the trial court's findings. What the trial court did say at the conclusion of the proof was this, that this child was going to need both parents. The state wants the court to overlook that, but that was the trial court's way of saying, after all I've heard, after all I've seen via exhibits, I find that this child is going to need his foster parent and his biological mother. And there's only one way to accomplish that, and that would have been denying the petition for termination as opposed to granting it as the clear and convincing evidence standard would have required. We're asking the court to reverse the trial court's decision. Thank you.
Thank you. Thank you, counsel. We appreciate your argument. We will take the matter under advisement and will attempt to render an opinion at the earliest possible time. We will be in recess to the call of the docket this afternoon.